discussions in becoming voting members in the absence of other members or when a member abstains for conflict of interest. Present tonight are Mr. Mayor, Ms. Kronowski, Ms. Lavelle, Ms. Towsley, and I am Betty Hollow, Chair. Also present is Paul Eschenbacher, our Acting Secretary, and Zoning Administrator, John Paskey. The Board operates under the following procedure. The Chair will name and describe the case. The Zoning Administrator will state the basis of the objection and any applicable facts or conditions pertaining to the case. The appellant or their representative will give reason why the appeal should be viewed favorably. Anyone wishing to speak in favor of the request will be heard. Anyone wishing to speak in general comment will be heard, and anyone wishing to speak in opposition will be heard. If necessary, the appellant or their representative will offer concluding summary or rebuttal remarks. Testimony from the floor shall be closed. The Board will deliberate and render a decision. According to Athens City Code Section 230703B, the Board has power to grant variances from the strict application of the Code, provided the variance will not be contrary to the public interest, the spirit of the Code is observed, public safety and welfare are secured, and substantial justice is done. According to Athens City Code Section 230910C, variances from the Code shall not be granted unless the Board finds, based on direct, specific findings of fact, that each of the following conditions has been supported. Practical difficulty and undue hardship. Because of extraordinary or exceptional circumstances or conditions pertaining to the specific piece of property, a literal enforcement of the regulations will result in a practical difficulty or undue hardship that is unnecessary to the achievement of public purposes. Exceptional circumstances. There are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone. Preservation of equal property rights. Literal interpretation of the regulations would deprive the applicant of rights commonly enjoyed by others in the same zone and the same vicinity, while a granting of the requested variance will not confer on the applicant any special privilege that is denied to other properties in the same zone and the same vicinity. Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property. Absence of detriment. The authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or the public interest. Not of a general nature, the condition or situation of the specific piece of property or the intended use of the property for which the variance is sought, one or the other or in combination, is not of so general or recurrent in nature as to make reasonably practicable the formulation of a general regulation for such condition or situation. I don't think we need this section tonight. Any person, resident, or officer, department, or appointed body of the City of Athens aggrieved by a decision of the Board may petition the Athens County Court of Common Pleas concerning the illegality of the decision. Such petition must be filed within 30 days after the mailing of the decision of the Board to the applicant. There are 3 cases on tonight's agenda. They are Case 11-26V at 27 Meadow Lane. I'm sorry, I'm reading the second one first. The first case is this the order we're doing them in?
Yes.
Okay. All right, the first case, excuse me, is 1203V. This is at 184 Longview Heights Road. This is an R1 zone. Jesse C. Roberson is the appellant. He is requesting a variance from Section 230805C to allow expansion of a parking lot from 27 spaces to 40 spaces without paving or marking the lot, where paving and marking the parking lot is the minimum requirement. The second case tonight is 1126V. This is at 27 Meadow Lane. The zone is R3. Ahmed Faik is the appellant. He is requesting a variance from ACC 23-10-01A, Schedule of Bulk Controls, to allow an addition to a non-conforming structure with side setbacks of 0 feet, where 8 feet on one side and a total of 20 feet on both sides are the minimum requirements, and lot coverage of 61%, where 30% is the maximum allowed. The last case is 1204V. This is 22 West Stimson Avenue. It's Zone B3, and the appellant is the Wasserman Group. They are requesting a variance from ACC 23-10-01A, Schedule of Bulk Controls, to allow construction of a commercial residential mixed-use building with a rear setback of 12.5 feet, where 30 feet is the minimum requirement. Let me just say before we begin that Ms. Towsley and Mr. Mayor are alternates, but in the absence of other members, they will take full part in the discussion and the voting tonight. The board is required to take testimony under oath, so would anyone wishing to speak concerning any item on the agenda please stand? Yes. Do you swear or affirm that any testimony you will present to the board will be the truth, the whole truth, and nothing but the truth? Thank you. So we are ready for our first case, which is the Longview Height parking lot issue. So would you, Mr. Pesky or Mr. Eschenbacher, tell us what we need to know here?
Okay. These people came before the zoning board in November of 2009 with basically the same request. They wanted to expand their parking lot without paving or marking the lot. That variance was approved, and then for whatever reason they were not able to act on it or did not act on the variance within a year. So basically they're coming back and asking for pretty much the same thing, 40 spaces instead of 39, but it's the same variance.
Okay. The variance that was approved previously and expired.
Yes.
Okay. Mr. Robertson, would you like to describe it more in detail what you all are trying to do? If you'll come forward, give us your name and your address, then you can tell us all about it.
While he's walking up there, I'll add, it did go through Shade Tree back then as well and was approved as presented this time.
All right. So that's already been done and in place?
In the previous application, but they have a 2-year window, so it's that part hasn't expired. So.
Okay. All right. So they don't need to worry about the tree commission. Yes. Name, address?
My name is Jesse Robertson. I live at 8199 North Coolville Ridge Road. I am co-president of the executive committee of the Unitarian Universalist Fellowship of Athens.
Okay.
Our hope is to accomplish 3 things with this project. First, and most obviously, we would like to expand our parking lot, which currently holds about 27 cars maximum. The expansion will allow us to go from 27 cars to 40 cars and to make it more clear where precisely people are to park. As part of the project, we also intend to put barriers along the edge of the parking lot to guarantee that no one can go over the side of the hill trying to park.
That sounds useful.
I don't know how familiar people are with the property, but the property is really uneven, so that part of what we're trying to do is, in addition to paving the parking lot, to put in enough drainage to eliminate water problems that arise with the building every time there's heavy rain. If we paved the parking lot with asphalt, we fear that it would just exacerbate the runoff problem. And finally, a major objective is trying to enhance the safety of the parking lot. The way it's currently configured, realistically, people coming into the parking lot can't see whether there's anybody coming out, and people in the parking lot really don't have a good line of sight in either direction coming up onto Longview Heights. For that reason, we would request that we be granted this variance.
Do you have questions or comments? I think we've all seen the narrative, certainly, and we've also had a chance to look at the topography and the plans for rearranging the lot, because that's really what it is, isn't it?
Yeah, and truth be told, I really think that doing this renovation is a benefit to the entire neighborhood, because on those rare occasions that a fairly large gathering is going on in our building, there is the risk of people trying to park along that road, which only exacerbates the safety concerns. I think the expansion to 40 cars is more than are ever likely to be there, and will eliminate the problems, the hazards that are posed by people parking along the side of the road and either being on somebody's front yard or being partly off the road and partly on the road. Yes, ma'am.
Just one quick question. In the original drawings, and I think in the original narrative, when you originally applied, you mentioned 2 handicap spaces. I'm
Yes.
assuming you still will.
We have those, we have already done those.
Okay. Oh, okay. That's why they weren't in this
Yeah.
recent narrative. Okay. Thank you.
Yes, sir.
Do your plans call for a paved apron to help defray any degradation to the roadway?
I can't answer that. I brought the contractor with me to answer those kinds of questions. If I can defer to him for that answer.
Can we get
Mr. Sass?
you to come? And again, will you tell us your name and address?
My name is Carl Sass. I live at 13036 McDougal Road in Athens. And as far as the paving of that, we weren't going to actually put any blacktop paving up through there. What we're going to do is the slope that goes up to Longview Heights, we're going to level that off and have more of a flat spot up there towards the top, so that the cars are more level when they get up at the top of the hill to get onto Longview Heights.
That the question of the apron has to do with the gravel spilling out into the road.
Well, the
Or
gravel
the
right
roadway
now is-
itself deteriorating towards your driveway?
Right.
Right. Well, right now, the gravel, the pavement is, crumbling over and coming down, and what we want to do is put a flat spot up there so that won't happen anymore. I mean, we weren't going to use any blacktop because it really won't, it just move the problem forward, is all it would do.
Or even possibly a cement. I mean, we've had some of these issues in town, people gravel driveways and ask them to do a sort of lead-in with cement or pave so that the gravel doesn't then spill out into the road. Right now, you go up, so more or less the gravel's not necessarily getting chunked out onto the road, it's more or less the road coming in. But if you level that out and there's gravel coming out into the road, I think that's what we're talking about. It was something I had thought about too, is there's some way you can do a lip to free up, I don't know, 10 feet or...
We could probably accommodate that. We can address that and put if you would like an apron on there of blacktop or concrete, either one.
Other questions or comments? Anything else? Okay. You all can just sit down, and if we have further questions or you want to summarize, you can come back. First, I want to ask if there's anyone here who would like to speak in favor of this variance. Anyone who wishes to speak in general comment about the variance? Anyone who wants to speak in opposition? Okay. Anything else you feel we need to know? No? Okay. In that case, we'll close the floor and have a bit of discussion, or at least go through the findings and discuss as we go along.
You want to make a motion?
Yes, we will need a motion first.
I move that the board consider case number 12-03V, 184 Longview Heights Road, to review requests for a variance from section 230805C to allow expansion of a parking lot from 27 spaces to 40 spaces without paving or marking the lot, where paving and marking the parking lot is the minimum requirement, and that we consider a lip at the end of the parking lot to lead into the street
Okay, as a condition.
as a condition.
Okay. Anything
I
else?
second.
Okay. So let's go through the findings. Is there exceptional or extraordinary circumstances that if we enforce the code literally will create an undue hardship that is unnecessary?
Well, water runoff, definitely. It's very sloped, and there's, I'm sure, a lot of water problems running down the hill, so it'd be much better to have the water drain down directly than overflow.
All right. Any other exceptional circumstances that apply to this property and not to the others in the same class or zone?
I don't think so.
And no
I think-
exceptional
Well,
circumstances?
it's tiered.
Yeah,
So
okay.
that brings the water issue that Joan just said, so.
Right. And I think if you have been up there, and most of us probably have, the parking lot itself is constructed in a strange way now, so they're not necessarily being able to make the best use of the territory that they do have there. The next one is preservation of equal property rights. Literal interpretation will deprive the appellant of rights commonly enjoyed by others in the same zone. This, of course, is the only property of its type. This is an R1 zone, so most of the properties are single-family houses. So I'm not sure quite how you compare here. No one else has a driveway with 27 to 40 spaces? Okay, all right. Is this a minimum variance that's required to make the reasonable use of the property?
Yes. We've already approved it in a sense.
Okay, it has been approved
It's already
before,
been
and it's
approved
not
before.
any different now. The authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of the code.
Well,
Now
not,
we're hoping it will help with the cars
right.
off the street in crowded times and easier access to and from as well.
Okay. Not of a general nature. The condition is not so general or recurrent in nature as to make reasonably practicable the formulation of a general regulation for such a situation.
No.
That's unique where it is.
Yes.
All right, so are you ready to vote? Shall we begin with Mr. Mayor?
Yes.
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 And I also vote yes, so you have that variance, and you can speak to the code officers about what you need to do next. Okay. Okay, our next case is 1126B. This is a property at 27 Meadow Lane, and it has a history with us, so we will let Mr. Paskey or Mr. Eschenbacher describe the situation here.
Well, I suppose you want to know why it's back here.
Yes, we have heard it before.
Versus through the Planning Commission. Mr. Bittner, the Chair of the Planning Commission, did request an opinion from Pat Lang, our Law Director, and which way it should go. And Mr. Lang's response was that he has reviewed the relevant sections of the code and believed that the BZA is the appropriate venue for this case. While the code is not clear on the point, I believe the language in 210903 to be controlling in this situation, particularly in light of the fact that this PUD was approved more than 30 years ago. I have spoken with Paula Mosley and John Paskey about this as well and informed them that I believe the BZA should have the opportunity to review Mr. Paskey's denial. 21, while Athens Code, this is out of our code here, while Athens Code subsection 210926 implies that changes to the site plan, in other words, building additions, shall be in accordance with the procedure outlined in the approval process, meaning that the process starts over. But subsection 210903 notes that upon approval of the final development plan, the official zoning map shall be so annotated for the land area affected, and the district name shall be appropriately amended. That would imply that the proposed alterations be considered by the BZA and not the Planning Commission. Similar developments within any other zone change boundaries recommended by Planning Commission approved by City Council. So in other words, since this was a platted subdivision, fee simple lots that has been many years ago, every lot then is basically its own individual lot, much like any lot in the city of Athens right now. We have numerous houses that probably do not meet bulk controls, and if somebody wants to put an addition onto that, and they do not meet the bulk controls, even of the existing setbacks to the sides or whatever, it comes back. I deny it, and it comes through here.
Okay.
So therefore, this one, I believe, should be treated the same way. And at the time, Title 20, or the PUDs were in the zoning code back in 1981. Now they're in the Title 21, the land development or subdivision code. But back then, they were in, it wasn't Title 23, but it was the zoning code part of the code. So hence another reason that it should be here. So that's why we're back.
All right.
What role would other owners in the PUD or a homeowners association have in determining, an opinion or?
Well, there's quite a bit. I don't know if you were to read through their the deed restrictions, letter of permission from the adjoining owners, and they could probably speak to it more than I on that. But the way I look at it is I treat in this situation, I'm going to treat every, and this is kind of, as you've heard me say before, a trial run here, basically, because it's the first time, in my knowledge, that we've ever had a request for an addition to be built onto a townhome or condo on a fee simple lot. So, basically, I'm looking at it as its own lot that at the time was granted variances through the regulations of bulk controls for zero setback, lot coverage, etc. But as any lot, like I've stated before, within the city limits, that in time, if you want to do an addition to it, you need to bring it into compliance or request a variance from the BZA to get that same variance they had before, or what was existing. So, and my rule of thumb is that I've taken through the office is if you change the footprint, the roof line, the occupancy, change of use, those four, and I guess probably throw in what do you call it? I can't remember the word I'm looking for. Bulk or cubic content as well. But obviously, it's tough to do that without altering the roof line. So that's the other one that goes in there as well.
Okay, that's helpful. Thank you very much. Let's see who the appellant is in this case. Is it the owner, Ms. Donovan? Okay.
Bill Walker, and I'm appearing on behalf of the appellant. I'm not sure if everyone's received this, and I'll go over there.
Yes, we have a lot of paper on this.
Did you? Okay.
I think we have
We
this.
have an addition to it as well.
I think we have all of this.
Thank you.
We have this.
Not color, though.
Well, no. Okay. Will you give us your address and your name again?
I apologize. Bill Walker, and I'm at 211 Columbus Road, appearing tonight on behalf of the appellants. And basically, the board has before it an appeal by the appellants to a denial to add an addition to their structure at 27 Meadow Lane, which is set forth, the diagram of what they're wishing to do is set forth on page 4 of the appeal from the decision of the zoning administration request for variance that I just presented to the board. And it shows the current building status and then the building with the addition that they're proposing. Basically, what the proposal sets forth is an enclosure of their deck, and on top of that, to be added a room or an addition for purposes of a bathroom on the second floor of the house. The denial, and that's where I'm a little confused as we stand here this evening, the denial by Mr. Paskey was based on the failure to comply with the Athens, or the zoning code with regards to side yard, rear yard, and lot coverage. And this is a PUD. And I don't know how there's any violation of a side yard, rear yard, or lot coverage that we have in this situation that falls into the bulk controls of the zoning code, because the bulk controls don't apply here. This is a PUD. If you're going to look at the side yard requirements and say there's a failure here, we need a variance, well, I mean, these houses, you know, are built next to each other. They touch each other, so I don't know how we request a variance under the Bulk Control Act for side, rear, or even lot coverage as these structures were built pursuant to PUD, which are permitted to vary from the bulk controls. So quite frankly, I think that the permit had to be granted based on the fact that this is a PUD, and the reasons cited here just are not applicable to this particular case. But that being, let's put that aside for a moment. Let's take a look at the history of this property in particular. But first of all, I want to alert the board that contrary to what Mr. Paskey may have indicated, either to me at another time or this evening, there's going to be no encroachment with this structure into what is now the existing backyard or back setback as it exists today. And I have the contractor here who can testify, but we are building within the footprint of the existing structure. And again, looking to page 4, there is no part of the addition that is going to extend out beyond the existing footprint of the house as it stands now if we enclose, if we're permitted to enclose the screen porch and add the second deck onto it, or the second level. The roof line is not going to extend out beyond the existing roof line that now exists with the structure. The roof line there on the first floor, part of the building there to the left as you're looking at it, the addition and the roof line on the addition are not going to extend back beyond or encroach out beyond the existing roof line of the house now. So there's no encroachment into the back setback. There's no encroachment into the side setback. So I quite frankly, I'm just again confused as to why the permit was denied. But looking at the history of this, and Mr. Paskey said he's not aware of any other times when there were additions made to these buildings, the structures out there, that may, and I'm not sure in what context he said it, maybe that was not brought before the code enforcement, but there have been. And we have attached to the documents you provided, if you look at Appendix A, it shows a history of all of the construction on all of the residencies in this subdivision. If I may approach the board.
We have copies of it. We have copies.
You have copies of that? Okay. Thank you.
Yes, you mean Appendix 1?
Yes, Appendix 1.
Sure.
In fact, if you look at 86056, 27 Meadow townhouses, back in 1986, there was a permit given for a concrete pad to set a portable whirlpool, wood frame deck with fence, brick sidewalk, and a plastic gravel. And that was granted by the zoning board here. And in fact, if you look at 2009, the appellants petitioned this, asked for a permit to construct a rear deck on the second floor, and that was granted to them. And that was not constructed, but application was made, and it was granted. We also have there other instances where permits have been permitted for changes to the residential structures existing within this PUD development. Let's go one step further when we talk about not only the history of the property, but let's look at the history of the area, and specifically, I think the board has before it a petition in opposition to the proposed addition to it. Does the board have that as well?
Yes.
Okay, thank you. If, as a part of the handout that I just presented to you, near the end, sorry, I gotta find mine here. Oh, I'm sorry. Is a response to the petition. And it looks like this, the front page, and it was attached to the documents I just handed you.
A response to the petition. Let's just see if we find
There it is. It's page 1 of
Page
whatever
1.
section this is.
Okay, is that it?
In the rear,
Okay.
declaration.
Okay, declaration,
No,
appendix 4.
I guess that's what it is.
I don't seem to have appendix 4. Maybe
So
I
keep
do.
going forward from that
Okay,
point.
all right.
Keep going forward. And that's how I found it.
Okay.
There it is.
Response to the petition, okay.
Okay, so if we look at the response to the petition, and we turn through it, let's look at 2 Meadow Lane, one of the petitioners here today. There was an addition, back porch was added to that, the rear deck of the home, and a permit was requested and was granted with regards to 2 Meadow Lane. Let's look at 3 Meadow Lane. A permit was requested at the time to put an existing deck on it, and an existing deck was added pursuant to a permit. That's 3 Meadow Lane. We look at 4 Meadow Lane. No permit was requested by the then property owner, but there was a substantial addition made to 4 Meadow Lane out there. 8 Meadow Lane, no permit requested, and again, an addition was made to the structure by the owner that made that addition. 13 Meadow Lane, again, in addition to the townhouse, has a large deck to the end, much like we're asking on the enclosed, and we're asking to go on. But again, it was added without a permit, as we've reviewed all the activities with regards to the construction out there. 26 Meadow Lane, no permit was requested, and as you can see, there was an enclosed frame porch with a roof at 26 Meadow Lane. We go to 33 Meadow Lane, and again, these are all the structures on which petitioners have opposed the present request before it. There was an addition to the townhouse, has a brick patio at the end of the property that was added. No permit was granted for that construction. 35 Meadow Lane, a permit was requested, and a permit granted to Hodson. Renata Hodson on August 7th of 1987 for a modification of the townhouse. We continue to go, and I don't want to spend the whole evening here addressing it, but the remaining information I provided to you with regards to 6 Meadow Lane, 10 Meadow Lane, 16, 17, 20 Meadow Lane, 21 Meadow Lane, 22 Meadow Lane, 25, and 30. All have had additions applied for. Some of them are even the placements of outbuildings, which violates code. Code, but the restrictions on it. But we have in 10 Meadow and 6 Meadow, we have additions that consist of outbuildings that are added. So there has been quite a history with this PUD property. A lot of history by both some of the current property owners with properties that have been changed over time. And also quite a history in front of the Code Enforcement Office requesting permits, and permits have been granted. And we're simply requesting, actually, I'm not sure how we want to phrase this, we're requesting that a permit be awarded or granted because, one, we are not required to meet ball control. Number two, we're not extending out beyond the present footprint of the property, so we're not going to be encroaching, and the only thing we can encroach on is the rear, and we're not going to be doing that. If there's any encroachment, and so we have 50% less of the rear setback, or coverage area, that exists at this time, has existed, and quite frankly, was granted by the permit of the Monroes. So basically, we're asking the BZA to grant the appellant's appeal here so that a permit can be issued so they can put construction as set forth on page 4 of their application. Thank you.
Questions for Mr. Walker?
Just one quick question.
Sure.
At the very tail end of the screened-in porch, I didn't see any steps or exit way. Would it be cement steps, wooden steps? How would you get out that back door? Or the new piece?
There's an existing deck there. An existing deck.
I'm sorry, can you come on up? Yeah. This is Scott Brooks, the contractor. I think he can answer that.
Okay. And will you also give us your name and address?
I'm Scott Brooks. I live at 8488 Windfall Ridge on the other side of town. Yeah, there's an existing deck that this picture doesn't show that's already there. When we come out of the rear door of that, it would be just onto the existing decks that exists there now.
Okay.
I think we can actually see that in these,
Some of these
sort of
pictures.
before and proposed after. So, yeah, that gives us an idea. Except that it looks as if it needs steps. Right. Okay.
I thought it was my understanding that if this was approved, the deck was coming off because it was built in violation as well and never received a permit. And that was one of the things that you had talked about doing, bringing that in compliance.
Well, the bathroom is to be above the existing.
I'm sorry?
I thought that the deck that exists now was to be enclosed.
Not all of it.
Well, it has 2 screens apparently, and then the new bathroom would be built on an existing upper deck. Is that right? Which was requested and approved. At least a building permit was approved for the deck up top.
The upper deck was
Right.
approved again because it did not change one of the 4
Okay.
things I talked about. Didn't
Okay.
alter the roof line.
Sure,
footprint,
and it didn't
etc.
add to the cubic
Much the same with
content.
many of these that have been approved on this
Okay.
list that have been shown. And as you can see, garage for storage, denied. Building garage for storage, denied. There's many projects that requested that would have altered roof lines and such that were denied. A lot of the ones that were mentioned never came through our office and were probably
Exactly.
done illegally. So,
Well, and the other thing that some of the ones that Mr. Walker referred to as approved were only partially approved. Part was, said, no, you can't do that, but you can do this. So, okay. All right, other questions?
Yes.
In the list of declaration covenants, under F, it talks about damage and destruction, and talks about, and I think the second sentence, any townhouse which is repaired, rebuilt, or restored shall contain the same square footage of the original dwelling. So if we were to...
I'm sorry, Red.
Page 7 of the covenants, under damage and destruction.
Do you want to read that again, please?
Okay.
It says any townhouse which is repaired, rebuilt, or restored shall contain the same square footage of the original dwelling. If the addition were to be made, and something were to happen, a fire or something like that, and the house destroyed, you have to build it back without that bathroom addition, because the covenants require that. It'd be the original dwelling.
Yeah, that I can't, that we don't have a damage or destruction. I suppose we could hypothecate that if we had a fire there, it would have to go back to the original, and that may well be the case under this. But I would also submit that these restrictions do permit the additions to it, to the townhouses there. But I don't think that the damage and destruction provision that you said really is, and I say this respectfully to you, is not germane to whether they should be issued a permit, because if they have the fire and have to go back to original construction, okay, they have to go back to original construction. I can't argue that that's what it says, that it would have to go back to original construction. But I don't know if you're going to have a fire there that we couldn't come before the zoning board and ask for a variance on that.
You could, of course. But I think we may disagree about the intention of that part in the covenant, because it may not depend on some real destruction. It may depend on just adding square feet.
I'm sorry?
it may just depend on simply adding on rather than necessarily rebuilding. I'm disagreeing with you just a little bit about what it says. Okay. All right. Okay, anything else you want to tell us at this point?
Not at this time, thank you.
Okay, all right. In that case, is there someone or various people who want to speak in favor of this variance? Is there anyone who wishes to speak in general comment about the variance? In that case, we'll hear from people who are opposed to the variance, and I will note at the outset that we do have a petition, which Mr. Walker referred to, that is signed by 22 owners, I should say. In some cases, the name is duplicated because the person owns more than one property at Meadow Lane, but the totality of signatures is 22. And they say, "We, the undersigned property owners on Meadow Lane in the East Meadow PUD, Athens, we are presenting this petition." This was presented at the January 10 meeting to voice our opposition to the proposal to construct an addition to his townhouse at 27 Meadow Lane, Athens, Ohio. Okay. So, who would like to speak? Again, will you give us your name and address?
My name is Abby Lavelle, and I own a 3-bedroom, a 1.5-bath townhouse at 2 Meadow Lane. I have owned that for 6 years. I purchased it as it exists today, and the room or the finished area on my townhouse was an existing porch that a prior owner had enclosed. There was no additional square footage. It was a porch that was just enclosed on there. As I said, I've owned it for 6 years, and I comfortably have lived there and I did for a number of years with my 2 teenage children. And again, we only had 1.5 bathrooms and 3 bedrooms. My mother, Barbara Agranoff, owned the townhouse adjoining 27 Meadow Lane at 29 Meadow Lane, and she owned that for 16 years. She purchased it as it exists today. It has a screened-in porch that was a deck. They just screened that in, and that was the way it was when she purchased it. I was the power of attorney. I was power of attorney for my mother, and she lived there. I had 24-hour caregivers in with her for the last 6+ years. She had cancer and subsequently Alzheimer's, and she passed away on December 21st. I'm currently the trustee of her estate. My father, my parents were divorced, and my father became very ill. He's 91 years old, and I moved him in there prior to my mother's passing, and I'm his power of attorney. He's living there. Again, he's 91, and I've retained my 24-hour per day caregivers there. I have some exhibits that I'd like to share, if I could, with the board, just so you can, and actually I'm going to begin with photos, maybe, and I'm assuming that some of you have been there to see this. Just kind of a layout of 29 and 27 Meadow Lane. Well, I'll bring this over, but the point of delineation is the stain color. The people who owned it previously had stained it a darker shade. This is our townhouse at 29, and this is theirs. And I just want to make it clear that, as you see, it's a flat wall. This is the upstairs bedroom. No one uses the upstairs. My father is not able to walk any longer. And this is his bedroom. And as you can see, the light, and I know in the appeal documents it talked about the different light and everything else, but as you can see, the light comes in here. And just to give you a better view, again, this is the bedroom where my father sleeps, and the proposed wall addition will come out here with another porch area. So but this is my Exhibit 1 and Exhibit 2. There's Exhibit 1. And specifically regarding the property in question at 27 Meadow Lane, that property was purchased in 2009, and prior to the purchase, the current owner had spoken with me and many others and was well aware of the restrictions on the property and the communal nature of the PUD. We had many discussions about that. He discussed it with others. As I said, his townhouse was completely renovated by the prior owner. I was in there. It is a beautiful townhouse, 3 full bedrooms, and unlike mine, it has 2 full baths currently. 3 bedrooms and 2 full bathrooms, 1 up and 1 down that are existing in that structure. He's saying he needs all this room, but he is an unmarried man with no children. And I'd like to submit just the auditor's information on his parcel. Again, it's 3 bedrooms and 2 full bathrooms that are currently existing in that home. So that is as it exists right now. He also has an extensive deck off the back with additional rocks and bricks and everything else but right up into the edge of the property line, and I'm not even sure if it extends over. This is, as you can see, this is our townhouse right here. It's flush. The porch is screened in. It's flush. This is the deck that comes off of 27, and this is my Exhibit 4, and this is Exhibit 5, and this is what else is in the back. And obviously, it's not even close to complying with all of the not the variances, but the agreement that we all were aware of. Again, this is for their deck with my mother's townhome, and this is the way the rest of the backyard looks, all the way to the property line, which is supposed to be green space to a certain extent. Now, I'd like to tell you why I oppose this and why the other property owners also oppose this. I believe that, I'll wait till we can look at that. I believe that the proposed addition will negatively affect our townhouse at 29 Meadow Lane. And I just ask you to look at Exhibits 1 and 2. And then also, as you can see, if you just compare the photographs, the Exhibits 1 and 2, and you see where the wall will come out, and this is my Exhibit 6, showing how, and you can see the bedroom. This is my father's bedroom, and this is our upstairs bedroom, so I'd like to give you that. So that's, it will negatively affect our townhouse. It will block a view to the side. It will definitely restrict airflow. And it will absolutely, as you can see in the one photograph, restrict the light. I mean, absolutely. It's already, there are pine trees and other trees in the back. My father, he doesn't leave the house. I mean, and they're abutting up to one another. I mean, any work like this would have a devastating impact on his well-being and also on our structure. I believe there's the strong potential for structural problems if they're planning to add a second floor pulling off the top of that townhouse. I believe our property values will be decreased. I already believe that what has been added there has probably decreased many of our property values, and I do have other property owners with me.
Okay, would you like to have them have an opportunity to speak?
They will. They're going to, yes. Yes, they are.
Well, we do want to keep this moving along.
Yes,
so,
I'm sorry. Yes.
Yeah, especially if they want to speak too.
Yeah, yes. I basically wanted to state that, we really feel that this is a luxury request, and it's not based on need. As we said, I stated what is in the townhouse. We all, and I'm speaking for a number of them, and I will read on behalf of Joanne Larson in a moment, if I could.
Sure.
It's a planned unit development. We purchased with the same expectations, obviously. The limited airflow, and again, there have been screened-in porches and others. There is not one other property that has extended their second floor to affect another structure. At this time, and Joanne Larson owns the property directly or diagonally behind, so I'm speaking on her behalf. She asked me to. And she has written a statement that I'd like to read.
Yes, we'd like to hear.
Is that a...
Yes, go right ahead.
It says, "My name is Joanne Larson, and I live at 7 Meadow Lane. My backyard is kitty corner to the property of 27 Meadow Lane. My deck, living room, and upstairs bedroom faces 27 Meadow Lane and is separated by a small strip of land that contains some grass and mature trees. I am the original owner of 7 Meadow Lane, having purchased the property in September of 1983. This was a planned, restricted community that was and is appealing to me. I object to the building of the addition in question from the standpoint that the two-story projection would, in fact, block the upstairs view and affect airflow of 29 Meadow Lane, which is directly in back of me. If the variance is allowed, this would set a precedent for future variance requests in the Meadow Lane addition, adversely affecting property values. The enclosure of decks or other properties cited in the variance request does not have the same detrimental effect as the second-story projection would have. My two-story home has 2 full baths, 1 upstairs and 1 downstairs, just as the home at 27 Meadow Lane. I raised a teenager in this home and often have family members and other guests visiting me for days at a time. The 2 bathrooms accommodate our needs. I see no reason for the building of a 3rd bathroom at 27 Meadow Lane."
Okay, thank you. All right.
And obviously, you have our petition.
Yes.
And I guess I do want to just, on behalf of everyone, I would like to state that we hope this is rejected by the BZA. We request that you reject this. And we do believe, based on 23.0710, that the standards and conditions have not been met, specifically C1 through 5. I'm not terribly familiar with C6. I'm not an attorney. But we strongly believe that C1 through 5 have not been met.
All right, thank you.
Thank you.
Thank you very much.
I have one quick question.
Yes.
Yes,
Does the PUD have any kind of association that legislates any of these
It's not,
issues?
and I don't even, they're townhouses, so it's not like a condo association. There is no association.
Just an expectation when you buy into it that
Well,
things will
and all of
remain...
yes, you know, and again, that we do have the restrictions that were provided to everybody, that were signed, yes.
Which restrictions?
May I introduce?
When the PUD was created, the developers had restrictions for the people who bought it.
Okay.
Now, when we heard this, when it was brought to us not so very long ago, we thought this was an odd way to address it. It went to the Planning Commission.
Right.
They were concerned about whether the PUD regulations were still in effect and all kinds of things. They finally decided to send it back to us. So I guess we can assume that people bought these understanding the conditions of the covenant. Sure, okay.
Yeah. May I just, and
Well,
with me...
I'm going to let someone else speak.
Yeah, I was going to let them,
Okay.
they asked that I just introduce them.
Okay, great. Let's,
Because...
who else would like to speak
Yes.
about this
Do
opposition?
you want, well, do you want to do it? Go on. Yeah. Go ahead.
Yes, if you have something new to tell us.
I don't have anything in addition, I just
Okay.
strongly support.
Okay, all right.
My name is Ann Santa, and I'm the owner and landlord of those 6
Okay, all right, thank you. Okay,
Townhouses.
okay.
I'm going to give you her letter.
Okay. Is this Ann's letter?
That is Joanne
Joanne's
Larson's
letter. Okay, we'll put this
Yes.
in the
Thank you.
record, sure. Okay, save that. Okay. So is there anyone else who wishes to speak in opposition to the variance? Yes.
Hi, I'm Gail Berenson, and I'm one of the original owners also. Purchased in 1982, 3 Meadow Lane. And I decided that I also wanted to expand a little bit. I went to the developers, and I had read the covenants very, very carefully, and wanted to be sure that I was upholding what I had signed. And so I did not, the only thing I did was enclose the porch and knocked out walls from the interior, so nothing changed. The roof line did not change. I did not add a deck beyond that, so actually the wall remained exactly the same. But it was very important to me when I signed all those covenants that they be maintained, and they were really, as you know from reading them, all windows in the front had to be white and no boats parked in the driveway. And it was somewhat reassuring as I purchased that back in 1982 that those would be upheld.
Okay.
Thank you.
When you did change your deck,
Mine was one of those that was approved.
They all came with decks, did they?
Yes, they did.
Okay. And then some people screen them in?
Yes.
And some people enclose them entirely, is that right?
Yes.
Okay.
And in my case, it's an actual wall, and we...
Okay, so you have an enclosed room?
Yes.
And that seems to be the most typical request
And
that we
knocked out walls on
see.
the interior to make the living room bigger.
Okay. All right, thank you. Anybody else before we move along? Okay, Mr. Walker, any final rebuttal?
The owner had comments and response. Thank you.
Yes. And again, will you just give us your name and your address? We know your address.
My name is Ahmed Faik. I'm in 27 Meadow Lane. I just want to clarify some definitions that were used here and make it clear that when we talk with luxury, somebody is luxury, I'm asking for something luxury, it's wrong. Luxury is when we have two houses, one you can live in, one you can have your parent live in. I don't have that luxury. Okay. If I want to bring my parent girl out of the United States, if I want to bring them to stay with me, I need some space. I cannot afford to buy a new house. Mrs. Laval has that luxury, has two houses, and one she's living it, and the other one her father's living. And that's what I want to say. Luxury, we cannot use the term of luxury for to make it. That's one thing. And the other thing I want to clarify is about the light.
Okay.
Okay, about light. We're encroaching. We're right where the living room is. The wall is just extended. Beyond that, there is a deck that the permit was delivered for that deck.
Yes. Okay.
Okay. It was.
Are you talking now about the upstairs deck?
And downstairs.
The downstairs. You got a variance for the downstairs deck?
The deck for downstairs, they had a permit for that.
Do you mean the previous owner?
Previous owner.
Thank you.
Okay. So, for the first floor, we're just asking to screen in as everybody is doing.
Okay.
Nothing else. If everybody has the right to do that, I don't know why, I don't see why I cannot do it. That's the first thing. This is my right, I'm just asking for that. Second floor, that is just by necessity that I'm asking for that. I cannot afford to buy another house so I can grow my family bigger. Well, I'm just starting. So if adding one bathroom is a big problem for a society like this, it's not, for me, it's a necessity. I don't have two full bedroom. One full bedroom upstairs that is small, and second one in the first floor, and this one it doesn't have a bathtub. It has a just shower that is so tiny. Mr. Scott will tell you about. So tiny you cannot. If you have somebody that is sick, I cannot see somebody that is sick coming from upstairs to downstairs to take shower. That's not correct. That's my opinion. The light, it's not true. If you look at page 12 to page 13 from the document I gave you, there is a place where you can plug your address and will tell you the orientation of your house corresponding to the light sun when it comes out and which is set. That will tell you how much light you will have in the morning, how much light you will have in the afternoon. We're talking here about maybe 2-3 months, and about 2 hours in the morning. Is that will affect really the amount of sun coming to her house? My house in the middle is the one that will receive the less light in both sides. I'm in sandwich between two houses, and these houses in the winter, one will get the whole sun, and in the summer, the other side will get all sun that in it. And I will get maybe a little bit of sun between, if I'm lucky, between September, November, September, October, November, and that's it. That is really the sun is coming up and shining in my living room.
Well, I'm fascinated by your work here.
This is everybody can do it. There is a website, you can put your address, and this is by the government, it's not by me, and you can put your address and we'll tell you where is your house oriented towards. It's not true that I'm hiding or catching sun from these houses. They have more sun than me, and that's what all I can say. Thank you.
Thank you. Anybody else wishing to speak?
Just a point of clarification.
Okay, sure.
I think there was a misstatement there.
Okay.
Tim Monroe, the one permit that was granted, it was for a whirlpool tub that they put out back there back in, I think it was 86. You have it there. He made the comment that the permit was for my client to put in a deck. The permit was to put in a whirlpool, as it says there. Then the whirlpool was removed.
Which one are we looking at?
At 27, and we're looking at the Exhibit A.
86056 was the permit.
Exhibit A.
Deck, okay. That was approved. No.
Okay,
On the second floor, no, that was not approved. That was not approved.
I just, at 80, Tim Monroe, 86056, 27 East Meadow Townhouses.
Concrete, I see, okay. Portable plate.
Just for clarification, my client inadvertently said that that the permit was given for the deck. The permit was given for a concrete pad to set the whirlpool wood frame deck with fence, and it was built in and around, okay, with the deck going out.
Okay.
The whirlpool was removed then.
Okay. So you're assuming that this was approved, or you know that this was approved, because we don't have any evidence that it was approved or disapproved. We simply, okay.
Thank you.
Okay, thank you. Anything else that we need to consider here? Questions anybody has? Okay, we will close the floor and consider this variance. Questions you have, you want to talk about, things you're worried about?
Well, just to clarify, we wouldn't be here if the developer was still active and took on the role of making these decisions, is that right?
Well, as they pointed out, they were built in 81, 82.
Well, if you look at the deed restrictions, developer had a 20-year period, where then after that period, he was to go in and take his name off of the deed restrictions, which he did not do, which then carried it into another subsequent 10-year periods, which he would be into the second one. I have talked to the developer about it, and he says he feels the process that we're doing right now is what he would request. So.
Okay, but as far as we know, then the restrictions have been extended and are still in effect?
Technically, since the deed and the restrictions have not been modified at the county courthouse, he still has say.
Okay, and so the restrictions for legal purposes still apply?
If you look at the deed restrictions there, it's in one of the last pages.
Okay.
So
You're talking about B5, though. It says alteration and so forth can be done without the developer's approval. Right. And that's still in effect.
And that is still in effect because it's never been taken off the deed. And I did go down to county courthouse and talk to them about that. So in
So he's
essence, they still
designating
have...
us as his approving body? Is that what you're saying?
He called me up and he said, he told me, he said, I'm going to go along with whatever you're doing, John, and I proceeded or advised, go with the process we're doing, so.
Okay.
I don't understand that, though. How can we approve something prior to his approval when his approval is the key factor?
Yes.
Yes. I think it's his decision.
So he hasn't
He
taken
needs to
his
make
approval away, but he has, he will exceed
Yeah, I don't
what
know.
we
It's,
decided.
31 years ago, so.
And again,
informed prior council that he approved this if I went before the board and it was approved. That's what we...
okay, so
Right.
if we approve it, he approves it.
That's correct.
Okay, if we don't approve it, then he sticks with what he's got.
Do we have that in
Okay,
writing from him?
I think I've closed the floor, I believe.
We're
if I'm
also
not
allowed to
mistaken.
summons
Yeah, we don't have anything in writing, so...
when we need so, and I think we need
Yes.
the developer here so that we can question him
Right.
before we can...
You know,
make a
I'm not going to
judgment.
go down that way because this has been brought to us. We sent it where we thought it should go, which is the Planning Commission. They discussed that, whether they should consult with him, whether they should call him, whether the restrictions were still in place, and then they sent it back to us. So I am not going to now send it back to them.
I'm not asking that we send it back to the planning commission.
Well,
I want some
I
more
am
information
saying
from a
that
person that's not here.
If they, who approved this initially, thought that they needed to talk to him, and I believe some people have made an effort to talk to him, they found out that he would approve it if we approved it, then what should we say to him except to get him to say, yes, I'll approve it if you approve it?
Well, it's like he stated that we don't want to take we're not his spokesman, even though he said, whatever you say is good for me.
We have nothing in writing from the developer, and the developer in the covenants is the person who gives an approval for any alterations to the exterior of any of the townhouses.
Yes.
He hasn't done that. He hasn't given us anything in writing that he is asking us to make that decision for him. Nothing of that nature. So how can we
He believed the
supersede
process
a
that I
covenant?
took was the proper process by
I'm sorry,
denying it and letting it come here.
could you start that statement again?
Mr. Wentworth has called me and told me that he believed the process that I have taken by denying it and sending it to the board is the appropriate process since he has been so many years removed. And go this way, if you approve it, he'll approve it. If you deny it, he'll deny it. He doesn't, I don't think, have an opinion either way since he's been so long removed from the project.
He needs to be here under oath and say so.
Yeah, I think so, too. I think it's a loose wire.
Okay, does somebody want to make a motion?
I make
to
a
the
motion that
effect
we
just
table
call
this
in the
until we can
developer?
call Mr. Wentworth in and question him.
Mr. Lavelle, do you not believe Mr. Paskey when he said he talked to Mr. Wentworth about this?
I do. I believe that he did talk to him.
Then why do you need to hear it from Mr. Wentworth straight?
I need, because of what he stated in the covenant, that only that person can verify and authorize the change.
And
That
he told
person
Mr.
can't,
Paskey
that person
the process
can't,
he wanted to do that by.
But not in writing. And I would second
it's
Mr.
just,
Lavelle's
was it a
motion.
handshake? Was it a verbal? Was it a?
Verbal.
Do you have it on tape?
Well, now you're questioning me again. I said it was a
No, I don't know. I wasn't there. I don't know. He could change his mind tomorrow.
Well,
And if okay, let's assume the worst here. Let's assume Mr. Paskey's lying.
I'm not saying that Mr. Paskey's lying.
Let's say Mr. Wentworth changes his mind. There's an appeal process for this. He can come to the board and say, hey, wait a minute, you got it wrong what I told you. And then we can go ahead to the next, and if he is, in fact, been misquoted, or if this is not what Mr. Paskey has said, then Mr. Wentworth has the avenue to challenge it.
So what I hear you saying is you have a problem with the zoning board asking Mr. Wentworth to come before them so that we can ask him some questions.
I'm just saying, I think Mr. Paskey's word is good enough.
Is
And if
Mr. Paskey Mr. Wentworth?
is misquoted or something, he can file an appeal and we can rehear the case. I'm just trying to get this case going.
I would just think that something in writing would be appropriate, and the attorney for the appellant should
We
have...
can provide that.
Okay.
We can
you
provide
do
that.
understand that the Planning Commission has already discussed all this. I was actually at the meeting where they discussed it.
Yeah, I get it, but why is it so convoluted? Why didn't everybody bring everything? You know, sometimes we have these missing pieces.
Well, okay.
Was Mr. Wentworth at the planning commission or Mr. Soul?
I don't believe that either one of them was there, but the planning commission discussed at length.
Right.
How should we know what to do? We've got to call the developer, and perhaps they did, I don't know. You did.
I did.
You did. And he has acceded to us. So it seems to me at this point overly nice to insist that the developer appear before us and say what he has already said to Mr. Paskey, unless you truly do not trust either of those gentlemen.
It's not a matter of trust. I'm simply requesting that I would like to talk to Mr. Wentworth.
We have a motion on the floor. Is there a second to this motion?
I second it.
Okay.
Lavelle made the motion, and Mr. Mayor, you seconded it? Okay.
You made the motion?
No.
You made the motion.
I'll make the motion.
All right. So then let us vote. Mr. Mayor?
Aye for tabling it.
Okay.
Aye for tabling it.
I'm for not.
Aye for tabling it.
And I'm for not.
Okay. So I guess we're going to table this until we can have more representatives and more copies of many pieces of paper, which we appreciate. I love seeing the sunlight, where it goes, where it doesn't go. Okay? So we'll see you next time. Yes?
I have spoken with you about the next meeting,
Yes.
and I would ask that this be moved into at least no earlier than your July meeting because of the conflict that I have with your next meeting.
Okay, I would certainly agree to that, and I would have to accede to Mr. Eschenbach and Mr. Paskey, depending on what they tell us they can do. And when Mr. Wentworth or Mr. Soul or Mr. Bloom is willing to come. Okay, well, we're not likely, okay, all right. We do have the testimony that you gave. It has been recorded. Mr. Eschenbach is a wonderful note-taker. He can read your testimony at the next meeting, whenever that is. And we do have the petitions, and we have other documents that you have presented, including Ms. Lawson's letter. I'm sorry that we can't settle this, but maybe eventually we will. Okay.
We'll get that document.
Okay, so let us move along to the final case of the evening. Okay. The last case is 1204V at 22 West Stimson Avenue. This is a B3 zone. The Wasserman Group is the appellant. And as I said earlier, they are requesting a variance from Section ACC 231001A, bulk controls, to allow construction of a commercial residential mixed-use building with a 12.5-foot setback. Okay. Mr. Wasserman or whomever, would you?
Well, I can introduce it.
Yes.
Many of you, I'm sure, are aware of this situation. This is the site of the Bellavino. The applicant has come back to us with a new plan, reorientating the building a different direction and providing a commercial space on the first floor on Stimson Avenue, and then with some of the parking that he had before underneath the building to the rear of it, with the remainder number of parking spaces. The majority of it off of Stimson, and I think it's 6 spaces now off of Montrose where there was not before. 5.
I read 5.
Okay. So the plan has been changed from what was originally approved by the Planning Commission through Title 41, but they do need a request for the variance for the rear yard setback with this proposal. So that's the only variance that I can see is required.
Okay.
Quick question, Mr. Paskey. We have X number of, what is it, 800 square foot of commercial space is the parking that's in this diagram that we have, 20 spaces, I think. Is that sufficient for the
commercial space, if depending on the use that ends up going in there, right now they have 2 spaces identified for that. So if it was an office, 2 spaces is adequate because it's at 1 per 400. If it turns out to be a retail space, then they would need to add an additional 3rd space, which I do believe they could do in a little bit where that green space is there on the front side, or to the west side of the building, which then will require 1 per 200. So I don't think it was 800 square feet. 1 per 300.
Mixed use,
No, it's
1
1
per
per 2 on retail. Or I mean on bar or restaurant, which I don't think would happen, but 1 per 300 on the
Mixed use?
mixed, well, they end up being whatever the use may be, and we don't know. So-
Well, it has to be mixed use because it's residential and...
No. The way we do it is we count in the number of space. Mixed use means we've got 1-to-1 ratio for the
tenants,
bedrooms, for
yeah.
the tenants.
Right.
And then the other part would be whatever use goes in there. So if it's an assembly use or a restaurant or a bar, then it's at 1 per 200. If it's
Okay.
an office, it's at 1 per 400. So depending on the use, it's going to
Okay.
require how many
I got it.
parking spaces
Okay. I think
are
it said
required for that
business,
other part.
1 per 300.
I'm sorry?
I thought it said business, 1 to 300. Okay,
I'm
we can
just-
work that out
Right,
later.
exactly.
All right. Anything else you want to say before Mr. Wasserman tells us his story?
No.
Mr. Wasserman? Yes.
Just like to clarify, the table B off-street parking requirements for retail stores and shop, it's 1 for each 200 feet.
Okay.
So it would be 4 spaces.
So that's if it is a retail shop
Right.
rather than a business office of some sort.
Good evening. Rick Wasserman, I'm the managing partner of Wasserman Group LLC, located at 38 North Court Street, uptown in Athens. May it please the board, you have in front of you a brief summary of the plan. I have, of course, submitted the narrative required under law. This just simply hits the highlights. I'm just going to speak for a moment or two, and we'll see where it goes. Many of you know I'm going to build a project called Stimson Gardens. Perhaps you've heard of it.
Mr. Wasserman,
Yes.
may I suggest that you change the name because there's hardly going to be any green space, so why would you name it Gardens?
Well, it refers to garden apartment, which is a type of apartment.
All right.
But also,
Okay.
there will be significant green space as required under the tree commission law, but it refers to the fact that they're garden apartment. I have an approved site plan to build a particular building. Some controversy occurred when that plan went before the planning commission. Some folks were opposed to it because there was a structure there that's going to be torn down. Some were opposed to it because on the first floor, the only commercial activity was the parking of the tenants above it. Others were concerned that there would be traffic coming through the R1 neighborhood to get to the parking lot behind the building, which is at the grade of Morris Avenue and Montrose Avenue. This variance request is an attempt to deal with some of those concerns and try to make some folks happier about the project. Obviously, I could build the building that I'm already have an approval for, but I'd like to try to make some folks happy if I can. And so I've returned at some expense to myself, and I would say at the behest of the city planner, who was one of the people who suggested this to me. So here I am tonight. Unfortunately, there is no real opportunity before you submit a site plan to get this, to get this sort of feedback from folks in the city. I mean, pretty much the first thing you do is you meet with the city once for a preliminary meeting. They voice any objections there, and then you submit a site plan to the Planning Commission. So we really could not have foreseen the firestorm that occurred over the issue of whether or not there was a retail sort of business or some sort of commercial space on the first floor. In particular, we could not have foreseen that because so many projects with exactly the same design have been approved within the city in the last 15 years, on Fern Alley and Graham Drive and various other places. This particular plan that I'm trying to get approved tonight, which I will then take back to the Planning Commission, should it be approved, and say, hey, I'm going to build this building instead. What it does essentially is it turns the building perpendicular from the way that it was. It used to sit, the current approved plan sits parallel to Stimson Avenue. I'm going to turn the building perpendicular to Stimson Avenue. And that does several things for us. The first thing it does is it creates more room for parking because we're going into the hill. And with more room for parking, we can then carve out some room for a commercial space, in this case 800 square feet of commercial space that will front Stimson Avenue and thus become another storefront, if you will, along Stimson Avenue. In the old plan, there was just simply a parking garage in that space. The next thing it will do is it will dramatically reduce the visual effect of the building as viewed from Stimson Avenue. The building is approximately 90 feet wide when viewed from Stimson Avenue under the old plan. By turning it sideways, you'll only be viewing a little more than half of that, and the rest of it will be parking and landscaping and that sort of thing, and it will go deeper into the hill that is between Stimson and Montrose. The other thing that we will do by doing this is to reduce the number of cars that need go through the R1 neighborhood to get to their parking spaces from 9 down to 5, 44% reduction in the amount of traffic that will be going through the R1 neighborhood. And then the last thing is that we'll pretty much, I mean, it's impossible to know exactly, but based on the calculations the architect has done, we'll reduce the need for fill dirt almost completely. The old plan would have required at least some fill to be trucked in to backfill against a rather long retaining wall, because that retaining wall will now be less than half as wide because the building will be sitting the other way. There'll be almost no need for fill dirt at all. We'll just be taking dirt from one part of the property and moving it to the other. The building is odd-shaped. It does sit, rather the parcel is odd-shaped. It does sit in rather cocked from the road. There are no two sets of parallel lines in the lot. There are no right angles in the lot. Let's see. The only other thing that I would point out, I guess, is that where we are so we put this plan together, and the only variance it needs is for a rear setback. It doesn't need a variance for parking. It doesn't need a variance for anything else under the code. It needs a rear setback variance similar to the one that was approved at 31 through 33 Fern when they built their building there several years ago. I would point out that what it abuts, where we will be abutting the next property where the setback is not of the required amount under the code, is a paved parking lot that serves the rental houses that are immediately behind my parcel on Montrose. I'd be happy to entertain your questions. That's all I really wanted to say.
So when you talk about it abutting, we're not talking about property lines, we're talking about the building itself.
No, the property line.
Okay, so the end of the building, how close does that come to the hillside?
It averages 12 and a half feet.
Oh, yes, okay, sorry, I forgot all about that.
No problem.
Okay, thank you.
Okay.
So does that mean you're going to have to cut into the hillside facing the property on the right-hand side?
No, in fact, we'll be coming, well, okay, yes, to do this plan, we would have to cut into the hillside somewhat. The old plan, I mean, there already is a retaining wall there on the hillside. It's
right,
just
exactly.
Sort of old and
yes.
falling apart. We're going to essentially, in the middle of that, yes, we're going to dig further back into that hill and then build a wall there and then position the building perpendicular to the road, going back until it's 12 feet average from the lot line.
Okay, so you're going to cut into that hillside.
Yes, ma'am.
What about the people up above? Are they happy about that?
Well, I've not asked them. As I said, they own a parking lot there. Their tenants park on the
I know,
lot.
but wouldn't you be sad if you owned a parking lot and then somebody excavated under you and your parking lot crashed down into your building?
It's important to note we will not be excavating under them, just near them. No, they're not going to go underneath their parking lot, because that would be going over the lot line.
So the question, your lot line extends into that parking lot up on Lot Rose?
Do you have
It ends
plans?
at the parking lot at Montrose.
We've got the plans right here, you know?
It wasn't clear. I mean, if you were going back behind the original retaining wall on the right-hand side, that means you were going into the parking lot on Montrose, right?
No, that's not correct. There is a hillside currently there between the retaining wall and where the Montrose parking lot begins.
Okay, and how wide is that between the parking lot and the retaining wall?
I don't know for sure.
Is that's
It will be
obviously more than 12 feet, right? Because you're going to have 12 feet.
It's not currently a lot more than 12 feet, but it's probably 15, 18 feet, something like that.
So that means you would go into the hillside maybe 3 or 4 feet.
Exactly.
Is this what you're saying?
Exactly.
And then you would reestablish another retaining wall?
Oh, yeah.
Replace that?
Yeah, the new retaining wall will be poured concrete. It will not be concrete block is what's there now.
The retaining wall at the back of the building, that's going to be a part of the building.
It is absolutely going to be a part of the building, yes. The wall studs will in fact be pocketed into that retaining wall.
On the top of Montrose, I counted like 8, or is it 9 spaces from one edge to the other?
On my lot or someone else's?
Well, I just went up to the top of Montrose, and there's that, like, rectangular parking lot.
Right.
Overlooking the stairs and the old building.
Yes,
there were 8.
Is that all 8 lots? 8.
Well,
So, are some of those going to be gone
No,
when
that
you dig
belongs-
back into the hillside?
No, that belongs to someone else. That parking lot belongs to Mr. Phillips and Mr. Mitchell.
But I thought it ran rectangularly this way, in a straight line. I mean, there's 8 cars parked in a straight line right next to each other along that hillside.
May I approach?
Yes. Okay.
Up on the top of Montrose.
Against here. This is the parking lot. This is mine.
Which is,
Where's this at?
This is
Where
yours.
it's slopy
Okay.
ground right now.
but is
It's going to be
is
built up,
this,
level off.
is this actually
How do you get there?
at the top of the hill?
Through Montrose. Montrose comes down this way. The site, I guess you
Okay.
So here's the cars now. So you'll come and go past Montrose, and there'll be a new little road?
This will be Montrose. This is Montrose.
Yeah, this is Montrose, and it dead ends right here.
It doesn't. The
That's where
steps are
house-
considered to be
steps-
part of Montrose.
I know, they are.
Yes.
Where are the
If you look at the plat-
steps? Show me the
Well, how will you get a car from here to this
No, but
first?
where are they?
It just goes like that.
Okay,
They just turn
Mine's
it into
kind of
a
early.
right now.
okay.
The old plan had 9 spaces.
So the property line we can't see
So
is
it
in
comes
the dirt.
down this way.
So these are actually parked up on top of the hill
That is correct.
in a space that belongs to you?
That is correct.
Okay. And you're going to dig around over here, over here, over here?
All of this is the hillside currently.
Okay,
The parking lot
Then
of
here.
Montrose begins here.
okay.
So here's the old
property is
retaining wall
here.
right here.
Well, it's
He's-
not exactly that space.
Okay.
It's probably further up.
So you will attach the retaining wall to the back of the building?
That's correct.
And then there'll be 12 and a half feet?
That's correct. Yeah, you have it exactly.
So then why are you digging into the hill? Where?
Because the hill
Here?
begins here now.
Okay.
So we're digging into it to create this.
This, so to get the cars in there, you have to have 10 feet?
To get the building,
Get the building
you have to
going.
dig into the hill.
Yeah.
So the
The hill
retaining,
currently stands like that.
Big rectangular cookie cutter, he's got to go down and takes this part of the hill out. And
right, so that's a pretty big
Okay.
dig into it, that's,
Well, it's a lot smaller than the approved buildings do. Because the old building will require a 22-foot retaining wall the entire length of the property. And so by doing this, it becomes a lot smaller.
Okay.
so it's saving you money in the long run, is that what you're saying?
It saves money on the digging and it increases the cost in several other ways.
Does it balance out?
I couldn't tell you that for sure.
Okay, keep checking.
I don't really know. I'm being completely honest with you, I don't really know that. A lot of that has to do with what we put into this commercial space and how many different uses we make it usable for, because you can't, when you build something and you don't already have a tenant, you can't tell, is it going to be a restaurant, is it going to be a grocery store, is it going to be an office? So you got to put all sorts of different things in there, like venting and all sorts of HVAC.
I don't know if it can be, can it be a restaurant? I mean, is that not a restricted area?
Yes,
Yes.
although there is a restaurant there.
Well, it was grandfathered though.
Well, it was
But,
built
okay.
after, you know, I guess.
Oh, right.
Whatever.
It fell through the cracks, we don't know.
Right.
Anyways,
So, let me ask you this. You say that you will only have 400 square feet of this for public use, and you're retaining the rest of it for your own business for the complex.
No.
Okay, this says business tenant space. Okay, that does not mean you, it means whoever does it. Is that right?
Yes, are you referring to the thing that I wrote?
I'm looking to the plan, and it says business tenant space. I'm assuming that's a tenant who is doing a space, occupying that space. And then it says only 400 square feet will be
public space.
public space. That's a pretty small
If I may,
space.
that's, Mr. Valentor drew that up, and that's He's saying how much of that space will be for public, the rest of it could be restrooms, mechanical, et cetera, which we would then back out of the square footage calculation for parking.
Okay, that's what I'm
The
asking.
bulk controls
Okay.
in the code refer to something called floor space, and we interpreted that to mean the space that customers would use. And anything that's stock room or walk-in coolers would not be floor space. But I understand from Mr. Patchke that that's not actually the way it's interpreted.
Okay. All right, that is what I'm asking. Okay.
In the entrance.
And I wondered why you wanted to put the entrance on the side. Why is there not some reason to put the entrance at the front of the building?
I think in the end, the entrance will be in the front of the building.
Okay.
I mean, that was the architect's prerogative, but, you know, state plans have not yet been submitted.
Okay.
I suspect we will put the entrance in.
All right, and Mr.
Well, as of right now, with the 400 square feet, even at the most strict requirement of 1 per 200, that's 2 spaces, and those are the 2 spaces right in front of the door. Let's say, for example, he did end up needing a third space. As you can see, there is room to put in a third parking space right there to the left of the 2 by that current front door.
Okay, to the left of, what are you saying, in the green space?
Yes.
Okay, and so where's the green space going to be?
Well, this is a business zone, so it will not be required to meet the lot coverage regulations, but it will be required to meet shade tree, and that'll go through Title 41.
Okay.
And they do have the space to the rear of the building and to the west or east side of the building as well, which will all be green.
Okay, and so they do have room over there?
Yes.
Okay. All right.
More than there was before.
Okay.
I would just point out one other thing. If you had any other questions regarding how the lot sits relative to other lots, I think that you have this also. It's what was given to the Planning Commission. It's the actual site plan, and it has those parcels delineated clearly on here. You can see the way that the building sits in relationship to the buildings around it.
Right, so, yes, okay.
So it's actually sitting,
So all those lots are kind of wonky-jawed on the
and they're all going
Yeah.
catty-corner, except this one would be going in the opposite direction. Or
Well,
maybe it's going straight, and the
it's
other
going
ones are all
straight.
catty-corner.
I don't know how much you'll notice that or whether that's a factor. The parking lot's straight with the
Yes,
other
indeed.
buildings, okay.
Right?
Okay. Other questions to be asked and answered? Okay, you can come back when needed, if needed. Is there anybody who wishes to speak in support of this new plan for this lot? Yes.
I recently received 2 letters in the office, both letters of support, so with your permission, I'd like to read them aloud.
Thank you.
One is from Peter Kotzies. To the City of Athens Zoning Board, I have been an opponent to the current plan to replace commercial space with residential apartments and parking at 22 West Stimson Avenue. Upon learning that a variance was being applied for and the new plan includes a commercial space, I'm asking you to consider granting an easement exception and allow a more proper building for the street to be built. Business thrives when there are many establishments close together. Part of our success is based on being centrally located to other businesses so that we are a convenient stop on a street where many errands are run at the same time. On a daily basis, I have customers who drop off bikes for simple repairs and will go up the street to the pharmacy or the post office to do something else close by while giving us time to make the necessary adjustments to and get them back out on the road and trail. The proximity and ease of many services on the street benefits all businesses on the Stimson Avenue. Currently, Stimson Avenue is the only large B3 business area that services the Near East Side and should be encouraged as a business zone that serves the community. I understand that the setback will encroach on the R1 neighborhood behind the site, but since the lot affected is a parking area, I feel it is a good compromise to sacrifice the setback and retain a commercial space in the B3. Sincerely, Peter Kotzies, Athens Bicycle, 4 West Stimson Avenue. And the other letter is from Libby Markham to Athens Board of Zoning Appeals. Hello, my name is Libby Markham, and I own Busy Day Market at 30 West Stimson Avenue. As a business owner on Stimson Avenue, I support the variance request for Stimson Gardens, located at 22 West Stimson Avenue, because it will result in additional space for commercial activity on our street and thus help promote more foot traffic and commerce in general. I also think it is a worthy proposal because if approved, it will result in less fill dirt being trucked through the area to the site, which will reduce the overall impact of construction on other businesses, residences, and the environment. Thank you. Libby Markham, Busy Day Market, 30 West Stimson Avenue.
Thank you. Are there other people wishing to speak in support of the variance? Anyone wishing to speak in general comment? Anyone wishing to speak in opposition?
I'm Ron Luce. I live at 15 West Hills Drive, Athens. I want to say that I agree that this is a step forward, but it's not a big enough step. I'm trying to fix the microphone here, excuse me. I admire the idea of acknowledging that we need to have a business in a B3 zone, but that doesn't go far enough as far as I'm concerned. Mr. Wasserman was previously given a variance, in essence, through the Planning Commission, and now he's asking for a variance again. I think the variance that he received, as I have stated very clearly to everybody who wants to hear, I think was inappropriately given. And now he's asking for more special consideration. One of the things that he states is that this is going to have less visual impact because we're turning the building sideways, but the sides of the building are going to show from both sides, and I don't see that happening. If Mr. Wasserman wishes to change his building, I believe that takes us right back to the very issue that started the chaos that he talked about initially. I think it is inappropriate in a B3 zone to count required parking spaces for tenants as a business. In this case, what he's doing is, in my opinion, he is putting a business in the front of it, but he's still using the concept of the ground floor as parking spaces.
If I may interrupt, the variance is for parking, or at least for a rear yard setback, has nothing to do with parking.
I would argue that if he is going to entertain the idea of building a different building, we have to go back to the same basic issues, and I think that it is inappropriate to have parking spaces in this situation.
Questions, anybody? Thank you. Okay. Anybody else wishing to speak in opposition? Okay. Mr. Wasserman, do you want to have any last word?
I'm good.
Okay. Any other questions from you all before we close the floor? Okay. All right. Do you want to just go through the findings, or do you have other comments to make in general before we begin? Okay, we need a motion.
I move that we grant a variance in case 12-04V, 22 West Stimson Avenue, Zone B3, Wasserman Group. Appellant is requesting a variance from Athens City Code 23.10.01A, Schedule of Bulk Controls, to allow construction of a commercial residential mixed-use building with a rear setback of 12.5 feet, where 30 feet is the minimum requirement.
I second.
Okay. So let us look at the findings. The first one is practical difficulty and undue hardship. There's something exceptional or extraordinary about the specific piece of property. A literal enforcement of the regulations will result in undue hardship to the achievement of public purposes.
Well, he already has approval for the building going in the other direction.
Absolutely.
So there's really no hardship. Peculiar circumstances.
So the question is, would we be creating a hardship in giving this variance as opposed to the one that already exists? Would it be a hardship that's not necessary to deny having a back setback of 12.5 feet?
To the appellant?
Yes, to the appellant.
To the property and the
To the
project,
property,
not
okay.
necessarily the appellant.
Okay. Well, there are some exceptional circumstances. The whole thing is exceptional to begin with because
Right.
it started in a strange place and ended in a strange place. But more than that, the lot is backed by a giant hill, which is relatively unmovable. The lot itself is not perpendicular to the street and doesn't have, it's not a uniform lot in the sense of just, I guess it lines up with other lots on the street.
It does, they all
So
have,
perhaps
if
it's
you look
not
at that
exceptional
range.
in that sense, but there certainly are extraordinary circumstances.
Well,
to
they
the
were moving
property.
that wall anyways. That wall was part of the original. I mean, the trouble is so many of what would seem exceptional have already, he already has been given. So this is...
Well, the circumstances continue, they don't disappear, so...
Correct.
Well, I think they continue in a positive light, though, too. Less impact, he's tried to improve on some of the negativity that was not known until all of this came forward, so I give him credit for that.
Okay. Again, we're back to exceptional circumstances. They are circumstances that are extraordinary to the piece of property in question or its use that do not apply to other properties or classes in the same zone. Again, we're talking about the circumstances of the property itself, and there are some...
Well, budding a hillside is...
The other properties do as well. But
Right,
All do as well, and they are very
Yeah.
restrictive in the sense
Sure.
of how a building
Okay.
can be situated and built there, so...
And locating the parking spaces so it has a less impact on the residential area behind, and this plan does reduce that.
Well, except that he's cutting into, in the setback, moving a B zone that much closer to an R zone. And if you stand up there on Montrose in the parking lot, you can see the houses right up on Morris. So he's moving his structure closer to the
Well,
residential houses on Morris.
Perhaps so, but since I live in that neighborhood, and I
you
very
do?
much object to the idea of a business using access through an R1 neighborhood, I think 5 cars is much preferable to 9, absolutely.
Oh, I wasn't speaking so much of that as I was
Well-
cutting into the hillside.
Well, I understand,
That's what
but
I-
two
that-
things go together. Can we have fewer cars coming through there? I think that's preferable. Preservation of equal property rights. Literal interpretation of the regulations would deprive the appellant of rights commonly enjoyed by others in the same zone, in the same vicinity, while granting of the requested variance will not confer on the applicant any special privilege that is denied to other properties. And again, we're talking about a setback in the rear of 12.5 feet. That is what we are addressing, is the rear setback.
Well, it's more than, it should be 30, and it will only be 12.5. so-
Well, we don't know what other people have. I dare say setbacks of people who are grandfathered are probably not much more than that.
It's towards a parking lot as opposed to the foundation of a structure.
Correct.
Right, so it would be
Say
3
that
cars
Say that
as
again.
opposed to...
It's approaching or coming closer to a parking lot as opposed to the foundation of a structure. So in that way, I think it's less of an impact.
Okay.
And it's unique in that way too, so if somebody else is looking at something, well, are they moving close to a foundation of a house or to a parking lot that we can
Right.
look at in the future?
Okay, yeah. Is this a minimum variance required to make possible the reasonable use of the property? And he has already been given permission to make a reasonable use. I think that this is an improvement myself, so I would say that it's a minimum variance in considering the reconfiguration of the building and the parking, but, you have to decide for yourself. So, absence of detriment. The authorizing of such variance will not be of substantial detriment to the adjacent property, will not materially impair the purpose of the zoning code or the public interest.
It actually improves on
Yeah, it
what the
improves
original
it.
plan was.
I think it does, I do. And I think as far as keeping the hillside from falling down, I don't know that that's our worry. Let's let the architect and various others worry about that. Not of a general nature, the condition of the specific piece of property or intended use is not of so general or recurrent a nature as to make reasonably practicable the formulation of a general regulation. Certainly, I don't think so, and we would hope that we do not get into this situation of having to contend with what's on the first floor in a B3 again. But we'll see. Any public comments before we vote? Let's start with you, Ms. Towsley.
I vote yes.
I vote yes.
No.
Yes.
And I also vote yes. So you have your variance, and we hope that this will be a wonderful garden apartment. I look forward to seeing all those trees and pretty bushes and things. Okay. Shall we have some approval of the minutes from the last meeting? Anybody read
Isn't
those?
here, so I don't vote.
Who has read?
One word that I rewrote.
Or you could just hand that to Mr. Essenbacher.
I think there were two, that.
Oh, yeah, that
After
was
each
that
other.
funny little place he can
Yeah,
fix
that.
That's really not of consequence.
Yeah, okay.
for
No,
the
I
meeting.
approve.
Okay, so motion to approve?
Yes.
Second?
Second.
Okay, we approve the minutes. Any other business you want to take up?
Thank you.
All right, we are adjourned.